faculty of law at Hebrew University in Jerusalem. He's also a member of the Permanent Court of Arbitration in The Hague, and he was a former counselor for political affairs in the Israeli Embassy in Washington, the legal affairs advisor for the Israel Ministry of Foreign Affairs, Foreign Ministry's Deputy Director General for Arms Control and Disarmament, the Ministry of Foreign Affairs Coordinator for Combating Antisemitism, the head of the Israel delegation for the Taba arbitration and negotiations for peace with Egypt, a member of the delegation for peace talks with Egypt, Jordan, and the Palestinians. He was an arbitrator on the appeals panel of the International Commission of the Holocaust-era Insurance Claims Corporations, and he held the personal rank of ambassador. He's written widely and lectured widely, and he's included the procedure of international conferences from Cambridge University Press, which is in its third edition, international law, and the list goes on. So it's really a privilege to have Professor Sabel here, a scholar, a diplomat, and a legal expert to discuss issues of international law and anti-Semitism.
Sure, thank you. You know the classic definition of a diplomat. A diplomat is somebody who tells you to go to hell in such a way that you look forward to the journey. I don't know whether you know the Yiddish or Hebrew word chutzpah. Cheap. To discuss anti-Semitism sitting next to Charles is, I think, a new version of the word chutzpah. But I have no choice, so I'm going ahead. A good rule for a speaker is not to give away the end. But in this case, I'm going to break the rule. My subject is the role of international law in combating anti-Semitism. And the bottom line, and I hope you all don't get up and walk away, is there's very little international law can do in reality against anti-Semitism. Having said that, I'll try and plow into the issue, but bear in mind, the answer will not come from international law, and I'm sorry, I apologize, it's my feeling, it's not the right answer. Every lawyer has to start off with a definition of anti-Semitism. You mustn't go through this through the whole of the symposium here, and there is no legal definition of anti-Semitism. The law hasn't defined it. I'm taking as my working reference two definitions, and you must already know them. One is by the OSCE, Organization for Security and Cooperation in Europe. Certain perception of Jews which may be expressed as hatred towards Jews. And it gives examples, making mendacious, dehumanizing, demonizing, or stereotypical allegations about Jews, such as the power of Jews collective, Jewish conspiracy, accusing Jews as the people of being responsible for real or imagined wrongdoings committed by a single Jewish person, denying the scope of the Holocaust, and I'll come to that later, accusing Jews of inventing the Holocaust, and accusing Jews of being more loyal to Israel. And of course, I'll come to the Israel issue later. And the other definition that I like, I've taken from a report to the UN Commission on Human Rights, which gives the following definition. Anti-Semitism is a despising of Jews. This sentiment can be considered to be one of the root causes of racial and religious hatred. It has served to convey certain beliefs, myths, fears, and fantasies that have fired the imagination of generations of men, women, and children. Pseudo-scientific anti-Semitism has been spread for the past 150 years, reaching its zenith, of course, in Nazi anti-Semitism and genocide. It has stamped in people's mind caricatures and hateful images of Jews, traditionally linked physically to Satan, usurers, exploiters, and conspirators, the product of a Christian doctrine which in the Middle Ages accused the Jews of deicide, specifically the killing of Jesus Christ. The other issue of definition is, and I'll come to the Israel one, is denying of Holocaust, an aspect of anti-Semitism. And here I'd like to read a bit from a decision of the European Court of Human Rights. So I'll come back again to what this court does. And I like it. Denying crimes against humanity is therefore one of the most serious forms of racial defamation of Jews and of incitement to hatred of them. The denial or rewriting of this type of historical fact undermines the values on which the fight against racism and anti-Semitism are based and constitutes a serious threat to public order. There, of course, is the famous English definition of an anti-Semite, which you all know is somebody who dislikes Jews more than is strictly necessary. I think it's true to say that anti-Semitism is not only an issue which concerns people worried about the Jewish people and their name. It serves to a certain extent as a litmus test, I think, for any society. And if you look back in history, you'll find very, very often that when a society begins to lose its democratic nature, deteriorates, the signs will be the litmus test of anti-Semitism. And I think it's a very valid test of the moral fiber of any society, of a democracy, of its attitude to anti-Semitism. And I think this is particularly important for us here trying to fix what the curriculum should be for teaching on the issue. This is an issue not only which concerns the Jewish people, it concerns any society. The treatment of Jewish people with anti-Semitism is a test of a society. One of the ways I think the Jewish people have tried to confront anti-Semitism, of course, is with Jewish humor, which is not normally part of a lecture on anti-Semitism. But I like the story of the Jewish person who says, I prefer to read anti-Semitic press rather than the general press. I don't know if you like to read anti-Semitic newspapers rather than Jewish newspapers. He says, yes. When I read a Jewish newspaper, I read about pogroms, about the problems the Jews have everywhere in the world, how they're a minority being persecuted everywhere. When I read the anti-Semitic press, I read they control the whole world, the banking. I prefer to read the anti-Semitic press. But that, again, of course, is a reaction of the persecuted people. You may know the story of the Jewish fellow who was sitting in a train, and a big fellow came out and kicked him. Well, that's because you're Jewish. So the poor little Jewish fellow cowering in the thing says, is that meant to be funny? And the big bully said, no. The Jew said, good, because I don't like that sort of humor. Again, Jewish reaction. Who is a Jew? Again, definition, luckily it's not part of my agenda, but how on earth do you define it? Again, you may know the story. This is a New York story of a Jewish lady who gets onto a bus and asks the bus driver, excuse me, are you Jewish? The bus driver says, actually, I'm Irish. But she persists and says, look, you don't have to be ashamed of it. This is New York. If you're Jewish, then says, man, I'm Irish, I'm Catholic, I'm not Jewish. But she continues, it's a third time. In the meantime, there's a queue of people behind her. She says, look, you can admit to it. He loses patience and says, okay, have it your way, I'm Jewish. She pauses for a moment and says, that's strange, because you don't look Jewish. Okay, that's one way of dealing with anti-Semitism. The other question is, can the law deal with anti-Semitism? And here I've got a brief, you'll be having a more detailed lecture on legal issues, but I want to touch briefly on how law can deal with it. As you know, law is divided into two fields, civil and criminal law. Civil law means one person, it could be a state, wants to get the court to order another person to do something, refrain from doing something, to compensate for some sort of damage. And the burden of proof is, which is more likely. Can this be used to sue for anti-Semitism? And again, the answer is in a very, very limited form, because it's worthwhile stating out at the outset, hatred as such, and we're going to come to criminal issues in a moment, is not even a civil cause for civil action. You can hate something. It's sad, But you can't sue somebody because he hates you. You can, obviously, if he's either discriminating against you, and most countries in the world have laws against discrimination based on race or ethnic, or inciting other people to act. There's a very limited field where you can sue. What about discrimination against Israel? No. Again, I don't think this can be pursued in any court of law. Because it's very difficult for an individual to say, I'm suffering because you're discriminating against Israel, and Israel obviously can't go to the civil courts of any other country. So I would encourage, if I was people fighting anti-Semitism, to try and use civil courts, but the proviso is only in countries that have impartial judicial systems, which, frankly, I know it's politically not correct, puts aside all the Muslim countries at the moment. Like, very few, if any of them, have impartial judicial systems which will enable somebody to sue for discrimination against. So it means you can pursue it in a court, in a state which has an impartial judicial system, and not many. But they can be done. The more interesting side, of course, is the criminal law. Criminal law means you're being punished for something. It's nearly always the state that will be the prosecution, but there are countries and places where a private individual can initiate, it's rare, but he can initiate a criminal proceeding. Can this help us in the fight against anti-Semitism? First of all, I don't want to give you a lecture on law, but most of you know that for an act to be criminal, you need two elements. You need the criminal fault, mens rea. You need the criminal action, actus reus. In other words, it's not one of them is not sufficient. To sit at home and have all sorts of criminal thoughts is not a crime. I dare to guess here that everybody at one stage or other sort of planned a perfect crime. Feel free, you can't be convicted of that. However, if you take action, you can. But the action itself also requires criminal intent. The same action that could be criminal can be completely innocuous. At my first class in criminal law at the university, I remember giving an example it was by Judge Agonat. You take somebody else's umbrella. If you do it thinking it's your umbrella, you have not committed a crime. So the actual taking, if you stab somebody, well, that's criminal. Quite well, it was completely by accident. So you need the two elements. You need an act with criminal intent. Actus reus and mens rea for a crime. Again, hating Jews is not a crime. It's not something which I enjoy, but it's not a crime. It requires some other element, action, to turn it into a crime, which it has done in certain cases. What would it be? Again, discrimination against Jews because of Jews, or incitement to others to hate or to discriminate. And many countries have, and I think this is one of the very positive elements of the development of law in recent years, have such laws under national legislation. But I must add, not specifically referring to anti-Semitism, except in very few cases. Most of it was generally, but it's accepted anti-Semitism is a form of racism. What it does do is issue, in most legal systems, and here I'm getting close to international law, is it aggravates an existing crime. In other words, if you assaulted somebody, and it was done because of reasons of racial discrimination or racial hatred, this makes it a more egregious, more serious offense. It aggravates the crime. It's not the crime in itself. It's an aggravating aggravation. If this is the legal framework, how does international law, can international law play a part? I must start off by saying international law is not a legal system which should be recognized by most lawyers as a regular legal system. Why? If you ask a legal any lawyer what is a legal system will say, well, there's a sovereign who will give out orders, instructions, and you'll be punished if you don't carry them out. And there's a code of laws, you know what it is, and the court will try it, and if you're sentenced to a punishment, then there's some sort of enforcement measure, the police or a prison zone. This is the legal system. It can be fair, it can be unfair, it can be partially impartial, but there's a legal system. This doesn't exist in international law. If you think of the world, first of all, sovereign. There's no sovereign in the world. Every country has some sovereign. In a democracy, it'll be the parliament or national assembly. In a dictatorship, it'll be the dictator. In an empire, it might be the emperor, but there's somebody there at the top of the pyramid. There's nobody at the top of the international pyramid. The United Nations is not the sovereign of anybody. It's an organization created by states, which gave them certain powers. There's no sovereign. Therefore, there's nobody subject to a sovereign. There's no international parliament who can make laws. There's no international book of laws. There's no international court. You may have heard of the International Court of Justice in The Hague, which looks like a court. You see all 15 judges. It looks very, very, very impressive. But it only has jurisdiction if states agree to its jurisdiction. No, that's not court of law. It would be very nice if you charge with a criminal offence in any country. Well, I don't recognise the court. And say, okay, in which case we won't prosecute you. We can't sue you. It depends completely on the agreement of the states concerned. And of course there's no international police, there's no international enforcement body. So we have a system which I'm calling international law and others call international law. You could legitimately put a question and say, is this really law? Or is it just some sort of custom of states behaving in a certain fashion? Well, however, since I make my living by teaching international law, I've got to somehow try and destroy this argument. And I think the most effective answer is most states, most of the time, comply with international law. Why do they do it? Reciprocity, they want to have a reputation for complying with the law, they want other states to comply with the law, there can be sanctions, there's a whole most states comply with international law. And if you think of international relations, it consists of an extraordinarily large amount of legal rules that are complied with on a day-to-day basis by states. Think of the laws of aviation. Most of you come here, flying over other countries. Do you have a right to, airlines have a right to fly over the countries? They have to pay, it works. The number of times you hear states having disputes about the law of aviation is very small. And the number of international flights is enormous. It works. The same is true of shipping. The same is true of commerce and of health and immigration. It works. Most of the time, diplomatic immunities. Most of the time, states comply with international law. Again, does that mean all states comply with international law? No. But I think it's true of any legal system. In any legal system, you get people who don't comply with it, but they're minority. Majority comply with laws, even though there's no policeman standing behind them. Why? Because it makes sense. It makes sense if you're driving in England. I don't know whether it makes sense to do so, but the English do so to drive on the left-hand side of the road. So most people do drive in England on the left-hand side of the road. But you may know the old story of the English gentleman who went to his travel agent and said, I'm going to France and I want to rent a car. And the travel agent said, I don't advise you to do it because they drive on the right-hand side of the road there and it's dangerous and you're not used to it. But I insisted. I said, okay, in a month's time I'm going there, I want to. 3 weeks later he came back to the travel agent and he said, cancel, I'm not going to rent a car when I'm in France. The travel agent said, I'm very glad to hear that. Why? He said, I decided to try it out in England first and it doesn't work. But most people do comply with it. Most of the time, the same is true of states. Most states, most of the time, comply with international law. Most states enforce it. And this will become particularly relevant when we talk about human rights. Enforce it internally. In other words, if you tried to sue a foreign ambassador in a British court, the court would say, stop, international law grants him immunity. When the question of whether former dictator of Chile, Pinochet, could be prosecuted for torture, the British court had to decide what is international law. Does it grant immunity to former heads of state? So it comes up one of our accusations of war crimes against British soldiers in Iraq and so on. Every state in the world has its courts enforcing international law. Again, in a democracy it can be enforced against the government. In a totalitarian state, no court is going to make a decision against the will of the government. But in democracy, so we see this in Britain, we see it in Israel, in France, the United States, and other countries. Courts have come out enforcing international law standards on states themselves. So if there's no parliament in the world and there's no sovereign, how is international law created? And the answer is a bit complicated. There's two ways that international law is created. The first is by states behaving in a certain fashion consistently over a long period of time under the conception that they are obliged to do so. It sounds a bit strange because circuitous. It's not really circuitous. In other words, where you can find that states have behaved in a certain fashion over years, in the vast majority of states, and why? Because they felt they had to do so. You created custom. And custom is binding on all states. It doesn't require positive decision by a state. The moment a state is created, it's bound by customary international law. By the way, I think this is true to a certain extent of most societies. English law, in its origin, was based on custom. And if you've been traveling through the English countryside, you may have noticed that practically every village, there's a green area called the common sometimes, or the things, which is kept green. And even suburbs of London, you will see this. Why? Interestingly enough, because under English common law, custom, you had to leave the part of the village open for everybody to graze their sheep. It's not very relevant today. You don't get many people in Hampstead grazing their sheep. But it's part, and it was never passed by any parliament. It's absolutely binding on every English society, every English community. There must be a certain area, which is now it's been turned into parks, which is one of the reasons England is graced with so many green areas, and so is London Park. Because this was a common area, everybody could graze their sheep. Why? That's how society had behaved since time immemorial. Same sort of international law. Foreign ambassadors have immunity since time immemorial. So when a new state is created, it doesn't have a choice. Say, well, I'm not going to grant immunity to ambassadors. That's it. Customary international law, same sort of maritime things. What about human rights? And here is an interesting issue. Is it true to say that human rights customary international law because most of the states, most of the time, comply with them? I wish that was so. I think the unhappy truth is it's very difficult to say that most states, most of the time, comply with human rights. But does that mean, therefore, it's not custom? And here, an interesting issue. Most jurists make the following argument, and you can decide whether you accept it. Obviously, we can't say most states. You just simply have to look at the composition of the UN, and you can't say most of them comply with human rights. But all states accept that they're binding and pretend that they're complying with it, or avoid it, which means they accept the idea that basic human rights are binding customary international law. So therefore we can say that they're custom even though they don't carry it out. Simply because no state, my knowledge is, ever stood up and say, look, there are no human rights. I mean, they have their own interpretation. Saudi Arabia may think that chopping off people's hands is a nice local form of complying with human rights. Most of the world would not agree. But they don't say, no, there are no human rights. So therefore the argument goes, yes, human rights are customary international law, avoiding the issue of do most of the states in fact comply with. The other form is of course treaties. But here's much simpler. When two states, it's usually states, agree to something in writing, take it online, it's binding. And most international law now is based on treaties. How does this fit in with human rights? Human rights are fairly, we all take it for granted, but it's a fairly new phenomena in international law. Why is it an aberration from classical international law? Because bear in mind, you're dealing here often with what a state does with its own citizen in its own territory. If you were to ask a classical 19th century, even beginning of 20th century international law, it would say, well, that has nothing to do with international law. International law deals with relations between states. At the most, with foreigners. In other words, they also accept it. When one state abused the nationals of another state, that state could have a claim. But if it decided to abuse its own citizens, that was an internal issue. And here we've seen, I think, a very, very positive development in international law, that it is no longer regarded as an internal issue of the state. It binds all states, including in relations to their own citizens within their own territories. And it's now, as I said, regarded as custom. So even as most states now are parties to international human rights treaties, but even those states that are not will be bound by customary international law regarding human rights. The origin of most of them came after the Second World War. And here I think it's true to say that the Holocaust gave a jolt to all those international lawyers who thought, well, we don't have to deal with internal issues. It's worthwhile remembering that the German Nazis were prosecuted for war crimes, not so much for the concentration camps. At that stage, they still had vestiges of the classical international law, so that's not really an international issue. When they shot Allied prisoners of war, that was an act of aggression. But the fact that they killed German citizens, oh, that's changed. And this gave the impetus to the human rights, to the attempt to bring human rights into the realm of binding international law, which, as I said, could be done either by turning it to custom, problematic, or by turning it into treaties. It started, of course, with UN General Assembly resolutions, the famous Universal Declaration of Human Rights. Eleanor Roosevelt, to a large extent, to the right of FDR, was the lady behind this. Here, it's important to bring up something that the public may not be aware of. UN General Assembly resolutions are not binding. They do not create international law. Though you often hear quoting General Assembly resolution, no state in the world is on record as saying, yes, they're binding. But the reason is political. If you look at who creates UN General Assembly resolutions, it's the UN, composed a couple of hundred states now. Vast majority of them are tiny states. So I don't know if there's anybody here from Micronesia. No, so I can make fun of Micronesia. Okay. But somebody once reckoned that you can get a majority, a 2/3 majority at the UN, which sounds very impressive. Imagine you telling a public, telling your students, 2/3 of the United Nations voted for something. That really sounds impressive. The minority third could consist of the United States and Canada and Russia and China and India and Japan and Indonesia and the whole of Western Europe. But they would still be less than 2/3 majority. What is the political impetus, the political relevance of such a solution? All the powers, the whole. Why? It goes on the very democratic system of one state, one vote, which sounds wonderful. But if you say, well, that means that, apologies for Micronesia, that Micronesia has the same vote as China, it's meaningless. Absolutely. Why do they adopt the system? Churchill's old adage that nobody could think of a better one. So the General Assembly goes by voting, majority, Micronesia yes, China no, but that's it. However, the creators of the UN, those who drafted the UN Charter in San Francisco, carefully made it clear that such decisions are not binding. The reason, of course, was that the states that created it, basically the Allies in the Second World War, even then, when there was only some 40 states in the world, were not willing to give majority decision an ability to make law. So the UN General Assembly cannot make binding resolutions, it cannot create international law. It can make little statements. I wouldn't despise them, they're important. And it's not my subject here. The only body decisions are binding the Security Council on matters of world safety, international world safety and peace. And there's very limited it can make binding, but it's more as the policeman of the UN, not the lawmaker. It can only enforce existing international law. The Security Council doesn't make international law. In certain limited fields, it enforces international law. So the UN General Assembly can pass resolutions, and the UN Declaration of Human Rights, passed by a great majority, a festive and important document, is extremely important. It's not binding. And the same is true of other resolutions they passed on discrimination. The way to turn this into binding law, obviously, was treaties. And we have a series of human rights treaties that are very, very important. Most states are parties to them, which deal with civil and political rights, economic and social rights, the abolition of racial discrimination, very important for the subject we're talking about here today. Treaties against torture, apartheid, abuse of children, abuse of women, a whole series of human rights treaties. Most states are part of them, which contain specific clauses. What happens to a state that doesn't comply with such treaties? And here the answer is pretty dismal. Somebody once made the reckoning that we don't really need human rights treaties. Why? Democratic states enforce human rights irrespective of the treaties. If you look around at democracies in the world, their courts will enforce the human rights, even if there's no international treaty. On the other side of the spectrum, totalitarian states won't enforce human rights even though they're parties to treaties. You'll find some of the most horrible regimes in the world happily sign on to human rights treaties. They don't care about that. Their courts are not going to enforce it against them. So do we need them? The answer is yes. It creates norms, which can even be useful in democratic societies. And you often find that human rights treaties are quoted in courts. Again, not binding, normally, internally, unless it's been legislation, but it carries. And here, another dismal failure. We, those who've been fighting anti-Semitism, have failed dismally over the years to get a single international treaty that explicitly refers to anti-Semitism. Even though the stimulus, the catalyst behind, for instance, the Convention Against Racial Discrimination was anti-Semitism, was the Holocaust. And this was said explicitly by the people who proposed it. For political reasons, the word anti-Semitism has never yet appeared in international treaty. And I'm ashamed. As an international lawyer, I'm ashamed of this. There were attempts, and they were defeated by, in one case, by the Soviet Union at the instigation of the Arab states, who saw this. This would be seen as some sort of support for it. We have general declarations. There's a International Convention Against Genocide, which clearly was a result of the Holocaust. He doesn't mention anti-Semitism. He does mention genocide, and mention anti-Semitism. In practice, the Convention Against Racial Discrimination has been applied, where the committee came to the conclusion there had been anti-Semitism, but no explicit reference to it. So how are these treaties enforced? And I said the record is pretty dismal. Each of the human rights treaties has a committee composed of usually 18 experts, theoretically appointed personally. You appoint Mr. Smith or Mr. Charles, Mr. Brown. However, political reality being what it is, everybody knows from which country Mr. Brown, Mr. Charles, and Mr. King. And if he comes from a democratic country, he may be completely independent. If he comes from Syria, he's not going to act against the wishes of the Syrian government. So, although many of the people, of the experts on this committee are really impartial, others are not. What do? They hear reports from each state on the implementation of these particular treaties. Each state has to submit a report. Most states are in arrears because it's a tremendous headache having to submit a report every couple of years. And the committee goes over with a report, summons a representative of the state to appear. I've appeared a number of times on behalf of Israel in the Committee for Elimination of Racial Discrimination. And they get information from not only from the government, from NGOs, from their own things, and they ask questions. It's a pretty gritty experience. They stand there and they ask you questions on this and questions on that. Some of the questions I remember stuck in my memory. One of them was, I proudly said that Arabic in Israel is an official language, and in all states they say yes, but we understand there's discrimination against another language. I said, what? Yes. We have a complaint here from the ultra-Orthodox Jews that Yiddish is not an official language of Israel. I said, yes, I'm sorry. Diplomats don't normally shut up, but one state, I remember, I decided to shut up. One of the accusations was, Israel is a racist state. How do we know you've got a religious symbol on your flag? The Star of David. How can you claim that you're a multiracial or a pluralistic society when your national symbol is a religious symbol? This discussion took place in Geneva. I was wondering whether I should make any comment. And around the table I saw representatives of the Scandinavian countries, of the United Kingdom, of Arab countries. Each one of them had a religious symbol. Literally, I said, well, I decided not to accuse the Swiss of racism. And you report back to your state. Is this effective? It's effective if you represent a democracy. The representative in Iraq or Syria doesn't give a damn what the committee thinks. They publish their reports, they're sent to the UN. If you're interested, you can find them, all these reports and the comments of the committees on the websites of they're called the treaty bodies under the United Nations High Commission of Human Rights. And you'll see, by the way, no state has a perfect record. And again, if you represent democracy and you have to present yourself, is it effective? I doubt, but it's the only thing here. Public opinion is effective in democracies. So is it a total failure? There's only one, I'm running short of time, so I'll end on the one positive note. The European community has taken action because the European community has a body that, again, I don't know how you people would know, the general public is not so much aware, European Court of Human Rights, which has the power to give orders to states to comply with its human rights. There's a European Human Rights Treaty, which is very similar to the UN Treaty, with the big difference, the big exception that it has a court to give orders, and individuals from the European countries, but it's not the European Union, it's the Council of Europe, which encompasses practically all the European states, including former Soviet unions, including Turkey. It can give orders to comply with human rights. And in the past it's proved to be very, very effective. unhappily it's becoming less effective since many states from the former Soviet bloc joined, and their record is patchy. Whereas, so if you look at how far Belarus has complied with citizens of the poor, even Russia, Turkey, when they've been ordered to pay compensation, they've paid. When they've been ordered to change their laws, they haven't. But could this be a model for the world? Unhappily not. You need a common basis. And to a large extent, the European community has it. Again, as it's enlarged, it's watered down. The court has dealt with some very difficult issues. The relationship between freedom of speech and racism. Is it legitimate to stand up and say, I hate Muslims or I hate Jews? Is that a violation? Or it's certainly a violation if you encourage other people to hate Muslims or hate Jews. They've had to dealt with this very, very delicately. But it does work. I don't think we're going to see an international court of human rights. There's an African court of human rights. There's a Latin American court of human rights. They're less effective than the European court of human rights. We're beginning to see this development. Will we see a complete, absolute international court of human rights enforcing it? I don't think so. So far, we have only the European court as a model. And again, if you have time this evening or any other time, go to the website, I would recommend, of the European Court of Human Rights. Choose any country and try and see the sort of issues that have been raised, and you'll find that every country has violations, including very democratic countries. Issues of anti-Semitism have arisen there and have been decided by the courts. Discrimination against homosexuals, against children. It turned out that the British courts still flog children, all sorts of things and the court have acted. So, since I wanted to end on some positive note on the field of international law and anti-Semitism, I would say, to a large extent, the European Court of Human Rights, with all its weaknesses and deficiencies, could in the future, if we manage to be a model for an international court of human rights. We won't get an international treaty for political reasons explicitly talking about anti-Semitism, but it's widely recognized and accepted that anti-Semitism is a form of racial, I think there's discrimination which must be combated. Thank you very much.
Yes, thanks a lot for your lecture. It's very interesting to know your evaluation regarding European states' currently situation to fight against anti-Semitism. For adaptation, for implement international law by the European directive for countering anti-Semitism, the most issue first before all is definition of anti-Semitism. Concept. Conceptual approach by each state, and European Union common legal basis. Until today, they didn't definiting anti-Semitism phenomenon by their each country state legal basis. But do you think that European Union has to open new chapter in fighting against anti-Semitism by legal basis or no?
Well, the European Union, in addition to the Council of Europe, of course, has taken up a definition, but a definition is binding only for that particular. There's no body in the international world that can make a definition of that. There's one point I should add. Certain crimes are international crimes as such. They don't need to be incorporated into treaties to be binding on states. For instance, in the old days it used to be piracy and slave trade. It now includes genocide or grave war crimes. Any state can try them. It's called universal jurisdiction. Any state can try somebody for if he's committed, even though there's no connection, no nexus with the state. And that's the distinctive element here. Any state that gets some forms of terrorism, that has a war criminal in its territory, somebody committed genocide or slave trader or contriving. Anti-Semitism is not in that list. It's not in the list of crimes of the International Criminal Court, which we're discussing. This is the latter time. We felt
The punishment basis of legal framework really remaining by the indifference of state government.
Exactly. It's what the European framework and others have said, encourage them to have legislation, usually as an aggravating element. In other words, if you committed a crime, you committed it because of racism or anti-Semitism, this should be a more serious punishment. But it will always be up to the national court. And national courts will only try somebody on the basis of a national criminal law. With the one exception which I talked about, international war crimes and anti-Semitism is not in that list.
What was the legal basis for what was the legal structure or basis for the Nuremberg trial? Was that international law?
It was international law. They based themselves to a large extent on the Hague Rules, which in 1907, a classic law of war. They added aggression as one of the crimes they committed of. And genocide was acted at the last moment, was pushed in by an individual who managed to persuade them, maybe by being a Ludwig, I don't know how you say a Ludwig by English, but genocide should be included. It's the only case that I know of where somebody has been charged with genocide. That was the Nuremberg law. But they base themselves on classic international law. Problem with Nuremberg law, it was a fair trial, but basically it was a trial of the victors against the vanquished. It was the Allies trying the Germans. This is even more so true in the Tokyo trials, whereas the US alone was trying the Japanese. And that's what led to, again, I could go beyond my time, to attempt to have an international criminal court. So that Charles will have to invite me for another lecture.
I'm sorry, but
They will, but
But concerning Nuremberg, it means they invented the concept of crimes against humanity, because genocide was adopted only in 1948. It was, I think there was only 4-year period of genocide in Nuremberg.
No,
it was not,
you're
definitely. It was
right about
crimes
that.
against peace, crimes against war, and they created crimes against humanity.
You're absolutely right that the international treaty against genocide was later, it was 1948.
1948,
but
1947.
Genocide was included.
No.
I think it was. We
It was not.
can check it. We can discuss it later.
Okay.
I think it was. Yeah.
Anybody else got a question or a comment?
Professor, we spoke about this very briefly, but what do you think about this idea of creation of the International Human Rights Court? But this was the idea developed by Professor Novak and Professor Shiny some years ago to create an International Court of Human Rights modeled on the European Court. But actually, it was like 5 or 6 years ago, and since then nothing happened. Do you think there are any chances for this?
I think it's a non-starter. Because how are you going to, let's say, how are you going to elect the judges? The only way would be by an international body consisting of all states. You're going to have a majority of non-democratic states. That's why you can, that's why I think the European Court of Human Rights is beginning to creak a bit, because you have states that are semi-democratic. Turkey used to be democratic, not so much. Belarus, even Russia, it's beginning, when it was only democratic states, it was,
Poland,
I'm getting in the political minefield here. Luckily Charles hasn't kicked me yet to stop, but it's problematic.
yeah.
More of a question, a clarification question. You know, in international law, there is just cogence, which is basically, you know, how do you link the understanding of torture and, you know, quote, after a crime is committed to just cogence and anti-Semitism? Could you just make some connections?
can I explain to the others who may not? Jus cogens is a fairly new legal term which means that laws are immutable. You can't not accept them. They're binding automatically. It's a very limited number of rules that you can't make reservations about. They include basically aggression. In other words, two states cannot make a state. If they make a treaty between aggression, that would be invalid. Or gross violations of human rights. What is clear is torture, biological experiments, racial discrimination. I'm not sure yet has been accepted as jus cogens. Because it's a very, very limited number of rules that states they cannot digress from. So I would like to see and hope to see that racial discrimination would become a jus cogens. I'm not sure that one could, at this stage, state it as jus cogens.
You just help us with that. I have the use as IUS. What's the second word?
So, jus cogens, C-O-G-E-N-S.
Thank you.
I always, by the way, I always like to quote Latin, because if I make a quotation of French, somebody can correct my pronunciation. In Latin, nobody can correct it.
I like that, so that's fine.
How would you describe the role of international law in spreading anti-Semitism?
Can you elaborate the question?
I mean, especially anti-Zionism. When I mean, singling out Israel, and this could be, or maybe, I think you have a general global discourse about Israel as, I mean, major violator of human rights, and some attempts to establish an international human rights court could be a tool of demonize Israel and concentrate all the accusations concerning human rights violations on Israel. This could be a tool for this strategy against Israel, and Jews in general, and Israel as a symbol of
Just looking for the quote that I wanted to
okay.
use. When we, represent the Jewish people, Israel tried to get anti-Semitism listed as one of the crimes under the Convention Against Racial Discrimination, the Soviets at first agreed. Then, under political pressure, they changed their mind. And the tactics they used was, oh yes, that's fine, and we'll also include Zionism. So they presented officially to the UN a list, and Zionism. And of course, they then arranged for one other delegate to say, no, we can't do this, let's adopt them both, so there's no reference to Zionism. Is hatred of Israel a form of anti-Semitism? I'd like to quote from the OSCE 2005, which I think is very important. Examples of the ways in which anti-Semitism manifests itself with regard to the state of Israel include denying the Jewish people their right to self-determination, for example, by claiming the existence of a state of Israel is a racist endeavor, applying double standards by requiring a big behavior not expected or demanded of any other democratic nation, using the symbols and images associated with classic anti-Semitism, being Jesus, blood libel, drawing comparisons of contemporary Israel policy to that of the Nazis, and holding Jews collectively responsible for actions of the state of Israel. And this was OSCE, and they said, of course, criticism of Israel is not anti-Semitism. Nobody, those of you who visited Israel know that we love to criticize ourselves and criticize Israel foreign policy. That's not the issue. But when one of these elements are, then I think it's become anti-Semitism. And to be politically correct, I don't know whether you people would agree, but I think most forms of anti-Semitism now try not to talk about Jews, talk about Israel, saying that they find it politically more correct. But basically, I think if you're talking about the Jewish state, in these terms, it's a form of anti-Semitism. Whether international law is behind it, I would say no. I'm an international lawyer, but it's certainly being used as a tool. And here I would agree with you.
Thank you very much. I wanted to ask you to clarify, if you can, what is today the legal status of the European working definition that you read, and also what is the status of the International Holocaust Remembrance Association definition?
The International Holocaust, the UN General Assembly also passed a non-binding political resolution, not binding on anybody. The European is a directive, which means it is a directive to states, but again, it asks states to take action. It's not direct action which the European can't do in this criminal field. It can't enact it. It's a directive. Those states that have complied with it have.
A quick follow-up.
Yeah.
2 months ago, I think, the UK government adopted officially the Holocaust Remembrance Association definition. Does it make any legal base for suits?
Rose?
It requires legislation in the UK, as you know, unless it's one of the European things that can go directly, but otherwise it requires legislation.
This is a delicate subject, but I'll bring it up anyway. A few weeks ago, I read an article in the German press about the discussion in Germany about the prospect of outlawing circumcision, male circumcision in this case. And I thought that the discussion was kind of problematic because the German government was making the argument that the circumcision of males was, I'm of course paraphrasing here, it was cruel and a violation of the child's right to bodily integrity. Yet at the same time, the German government was saying, but we're going to have to permit Jews and Muslims to circumcise their male children. So it seemed to me that this was kind of, for lack of a better way of putting it, anti-Semitic. You know, here's something we've decided that is cruel and inhuman and violates a child's basic right to bodily integrity, but we're going to let the Jews and the Muslims continue to perform this particular action. Is this something that's working? I could see this ending up in the Court of Human Rights in Europe.
I agree, but I think a counter-argument would be there are some people who say there are many doctors who recommend it for purely medical reasons. But I mean, it's beyond my field.
I was just curious, because this is something you would never read about in an American.
Whether you follow this issue.
Not exactly in Germany recently, but I think in Scandinavia and Joel knows in some other northern European countries, this is becoming an issue. The kosher killing of meat.
May I just
Yeah.
briefly add, if there is a national law that has a ban on such practices, then for sure such cases will go to the European Court of Human Rights, because the parents will claim that their right to privacy has been violated. So I'm absolutely sure, but I don't know if there already are such bans. I don't think so in Europe. But if there will be, like, legally binding bans, then for sure this will end up in Strasbourg.
And I think and just to continue, I think also on the traditional ways of killing halal or kosher meat is also wrapped up in this, and some nationalists are using it to sort of ban Muslim and Jewish practices in Scandinavia and
Belgium
Germany.
was banned.
Belgium is banned.
Well,
This also ties to the big problem of FGM too, right? I mean, so that's kind of a...
Yeah, but that's clearly, nobody claims it's necessary on medical grounds. Circumcision, there are many doctors who say this is a healthy question. Can I tell a joke on the issue?
It'll be interesting, go ahead. I was thinking of a few, but...
Somebody was walking down the street and his watch wasn't working, and he saw a store, and in it there was a clock. So he went in and said, "Can you repair my watch?" And the man said, "I'm sorry, I don't repair watches." I said, "What do you do?" "I circumcise." So I said, "Why do you put a clock in the shop window?" I said, "What do you expect me to put?" They're not going to regard international as a serious issue, are they?
So Daniel and then Phil.
There is an international organization called Office for Democratic Institutions and Human Rights, ODIHR, and it has a database about hate crimes in various countries. And my question is that, is there any sanction if a country doesn't provide data about their crimes? Do you know anything about that?
What are the sanctions of international law? Public opinion, condemnation of the UN bodies. How effective is it? That's all. Unless individual states sometimes decide we're going to sanction a state because of the violation of human rights. For instance, Burma, Myanmar, sanctions were imposed by various states saying you're violating human rights. But that was the decision of the US and other Western countries. But there's no international body. The Security Council only imposes sanctions when there's a threat to world peace. Or it has engraved cases of violation of human rights, but it's pretty rare. You've got to get the agreement of China, US, and the other permanent members, Russia and France. It's very rare to get it. So basically, there's very little that can be done against the state. But I wanted to end on a positive note. You forced me to go back on a negative note. Then you have a question.
Sorry
Yes.
for being late, and I overheard you mention FGM. There was a lengthy two-day workshop on FGM here, and I was even under a report of that conference. So if everybody would like me to send them the reference to that report, it's 36 pages long, and it's a very useful document because it goes into legal and health aspects of the problematic. Just come. Should I just send it to
Yes.
everybody?
Yes.
Please, okay.
And just to add, not to beat a dead horse, but on the FGM piece, I do think it's worthy of a conversation in terms of the way that language is used, because people have euphemized FGM, right? You know, as the mutilation part, and called it female circumcision. So then suddenly you have a word which has different meanings to different people, and it can fly under the radar. Well, we're against all circumcision. You know, so it's just a conversation for us in terms of how words are used.
Nice point.
Could you please elaborate whether the famous Security Council decisions 242 and so on have impact today on the legal status in Judea Samaria/West Bank?
Do you want to go on that?
Sure.
Resolution 242 was a Security Council resolution, but which wasn't binding, which was accepted by Israel, by all the Arab states, and by the PLO. So that's why it has a unique standing, and it's become the cornerstone of all agreements between Israel and the Arab states. It calls upon two things: the Arab states to make peace with Israel and to end the war, and for Israeli withdrawal from territories occupied in the 67 war. The argument goes, does it mean all territories? And the argument goes back and forth. The Arab states say, well, it means, natural meaning is all territories. And Israel points out, it doesn't say it. And there was a earlier draft, which not everybody's aware of, presented to the UN Security Council, which called for Israeli withdrawal from all the territories. This was not adopted. They adopted the slightly ambiguous UK drafted phrase from territories. And the UK says it means you have to negotiate. Israel's position is we're willing to negotiate. The solution will come from negotiations, and there will be withdrawal. We have to negotiate boundaries, and hopefully we'll be able to do it. But so far, I really wanted to end on a positive note. I'll say that these negotiations are going to have a positive result in a short time. I can't say, but Israel is willing to negotiate. And I think I try not to be political. On a political thing, we proved that when we face an Arab state that's willing to make real peace, Israel made real concessions to Egypt to reach the peace they wanted. Did the same with Jordan. If the Palestinians were really willing to reach an absolute end to the conflict and peace, we could reach agreement. But it requires Sadat on the Arab side. Perhaps it requires a Begin or Ben-Gurion on the Israeli side, I don't know, but it requires... Politicians don't like to make difficult decisions. Israeli politicians included, and they're going to have to make difficult decisions. I'm sorry that really digressed from the issue.
Anybody else with a comment or question? Okay, so on behalf of everybody here, Robbie, thank you very much.